Hey everybody, John Hambling here, John the Other, obviously. And as you might recall, I've talked about changes to law a few times on this channel. Most commonly, I've mentioned Bill C-51, which is now law, as well as Bill C-337, which is not yet law at the time of this recording. If you know the content of these two laws, you can skip ahead to the following minute point. I'll put it on the screen. Otherwise, the summary is as follows. C-51, which is now law, was an omnibus bill, which among many other things modified Section 276 of the Criminal Code in the following way. Prior to it becoming law in December 2018, Canada's Criminal Code Section 276 already had two rules about the admissibility of the sexual history of a complainant in a sex assault trial. The rules were that it cannot be suggested that an accuser's sexual history means the accuser is less than reliable, and it can also not be suggested that an accuser's sexual history means they were more likely to consent to a sexual act under question in a trial. So as a defendant, you can't argue that because somebody has a slutty history, they're probably a liar, and you can also not argue that because somebody has a slutty history, they're more likely to have been a slut for the incident under question in a trial. Now, that might seem counterintuitive, but the basic idea is that legally, sexual consent must be negotiated on a case-by-case basis, not treated as an established condition or an assumption. What C-51 did was expand the definition of sexual history to include any communications of a sexual nature. That means, as an example, if a complainant and an accused person had an existing relationship that included sexual content in their text messages, those messages could not be used in defense evidence without a hearing separate from the trial, which would expose that evidence to the prosecution and the complainant prior to the complainant giving their first testimony under oath in the courtroom. Now, before this was a law, a bunch of legal experts pointed out that the requirement of disclosure of defense evidence to the prosecution and the complainant before the complainant gives their testimony under oath violates the rights of an accused person and significantly changes the burden of proof, moving it onto the accused. And after this was pointed out, but before C-51 was a law yet, it was fast-tracked through its readings and made law in December 2018. Lovely. By contrast, C-337 proposes to put both current and new Canadian judges through a program of training specific to sexual assault. The actual training in question is not available to the public to evaluate, so it's speculated that this is probably heavily feminist indoctrination, which, due to its secrecy, might be a curriculum that constantly changes based on how well it takes hold in the mind of subject judges. That's obviously only speculation. It might also be pseudoscience that can be easily debunked if it's put in public eye. That's my speculation. But you wouldn't be entirely wrong to think that these laws have a purpose different than the stated goal of protecting victims who are always and in all circumstances 100% reliable, truthful, and 100% victims. You might get the impression that the goal of these laws is to move the conviction rate in sexual assault closer to 100%, regardless of the facts. There is, of course, a powerful motivation among the activists creating and pushing these laws to increase both the number of accusations as well as increase the rate of convictions to approach 100%. Because until they do this, the feminist activists creating laws like C-51 and C-337 have a very serious problem. Their doctrine tells them there is an all-pervasive, all-consuming epidemic of sexual assaults against women that is not at all evident in the rates of reporting or the rates of conviction in sexual assault, which at present are roughly comparable to the conviction rates of other crimes. So to resolve this conflict between reality and their doctrine, feminists have decided to recreate reality to match their doctrine by radically increasing both the rate of reporting and the rate of criminal conviction to approach 100%. The alternative would be to acknowledge the disconnect between doctrine and reality and contemplate the possibility that maybe their doctrine is in some way in error. Unthinkable, obviously. But the goal of increasing both the rates of accusation and the rates of conviction in sexual assault might not be as important as they've seemed to us prior to now. And the reason I say this is the SNC-Lavalin fiasco that is still ongoing. Now, for those of you who don't know, SNC-Lavalin is a gigantic construction and infrastructure company based in Canada, which is facing charges of bribery and financial fraud in Canada for bribing officials in Libya. The scandal or fiasco ongoing is that SNC-Lavalin was going to be prosecuted in Canada, but because the company employs a lot of people in Quebec, particularly in the district of Papineau, which is where Trudeau's Member of Parliament seat is, and because Trudeau wants to be re-elected, his office attempted for a period of several months to pressure the former Attorney General to give SNC-Lavalin an effective get-out-of-jail-free card, or what is called a deferred prosecution agreement. This would allow the company which had committed fraud or used illegal bribery to just say sorry, pay a fine, but not be found guilty of a crime, because if they're found guilty, then they can't bid on government contracts, which for them is where the big money is. The legal construct which would allow this, the deferred prosecution agreement, exists in law because it was snuck inside Trudeau's last budget bill. Pretty darn convenient timing if you ask me. But Jody Wilson-Raybould, the former Attorney General, when she was pressured by the Prime Minister's office, decided not to allow SNC-Lavalin to make use of the recently created deferred prosecution. She was going to let the Crown prosecution do their actual job and let the courts decide. And she resisted a campaign of constant pressure from the Prime Minister's office for a period of months, until he fired her sideways out of her job as Attorney General into the Minister for Veterans Affairs. And that role lasted a couple of months until she quit, mostly I think out of a sense of disgust at the lack of ethics of the Prime Minister and the Liberal Party under his leadership. But this is the interesting part. Jody Wilson-Raybould, the former Attorney General, has been almost uniformly praised as a person of great ethics and integrity for her refusal to give a free pass to corporate criminals and to stand on her values in the face of constant pressure from her boss, the Prime Minister. But at the same time, Jody Wilson-Raybould was the primary sponsor of Bill C-51, which is the omnibus bill that redefined text messages as sexual history, making texts with a sexual content unable to be used in defense evidence without a 276 hearing. And it was that which led me to think that the torrent of praise for Jody Wilson-Raybould was nothing but politically partisan BS. I mean, sure, Raybould stood up to months of pressure from the Prime Minister in his office, but how can we reasonably view her as a model of integrity when the law she sponsored redefined exculpatory text evidence as sexual history with a clear purpose of excluding or sidestepping that evidence? What I'm pointing out here is that the former Attorney General sponsored and promoted a law which changes the purpose of a trial away from discovery of guilt or innocence in the direction of suppressing evidence in the service of finding of guilt without respect for the facts. And yet, I have to say that Jody Wilson-Raybould is showing integrity. The apparent disconnect comes from what she believes in, which leads us to a question. What is a false accusation, and what is a non-false accusation? To me, and probably most of you listening to this, these are two very distinct and different things. But if you ask a feminist, they'll tell you that false accusations are incredibly rare to the point that they shouldn't even be considered. That's not something I agree with, but I recognize their truthful belief in that idea. What's never stated openly is that there is no distinction between a false accusation and a truthful one, and that guilt for an accused person exists as a product of the accusation, not because they did or didn't commit the offense they're accused of. Now, when we lay it out so plainly, this is obviously absurd, which is at least partly why feminist advocates don't spell it out like this. But there's a couple of other factors to consider which layer on top of this first problem. And the next problem is that of identity based on a collective. Patriarchy theory, which is a bedrock of feminism, starts from the concept that regardless of the individual choices and circumstances of each man's life, all men conspire to and benefit from the purposeful subjugation of women. And putting aside the notion that women as a class are subjugated, the important detail here is that the action in question, their subjugation, is performed by men as a class, not by individuals. The concept doesn't only include you being a node within that supposed collective, but it also extends backwards in time. If men mistreated women in the past, that was all men, including you, in the present, so you're guilty. So guilt in a single accusation isn't necessarily connected only to the individual incident of the accusation addressed. If all men are guilty, which is a point of dogma by now, then you're guilty too. And in case this wasn't muddy enough yet, there is also the idea that for an accused person, even if they didn't do the exact thing that they're accused of, they did something, somewhere down the line. Maybe this time we got the wrong guy. Oh well, you still deserve jail or to be ruined or to have yourself made homeless or whatever, because you aren't a perfect angel now, are you? You did something sometime. And all of that muddiness and blurriness is contained within that usual bland statement that false accusations are incredibly rare. We don't need to worry about the destruction of the innocently accused because innocently accused men don't really exist. You are a member of a guilty group. The guilt transfers to you from individuals within your group, some of them in the past. It transfers to you from other individuals who might have done wrong in the present. And it also transfers to you from unknown and hypothetical offenses that you committed yourself right here in your own life. Or maybe you did. But getting back to Jody Wilson-Raybould, who stood up to intense pressure from the Prime Minister without compromising her ethics, she does believe in the rule of law. But as the sponsor of Bill C-51, she also has to buy into patriarchy theory to some degree, collective guilt and collective victimization by class membership, and so on, which makes presumed innocence of the accused and the burden of proof on the prosecutor maybe not so important that we can't chip away at them piece by piece until they're gone. Of course, the law has conventionally been that great equalizer, making rich and powerful person, at least in theory, the same as a poor person when they stand each in front of a judge. But equality before the law doesn't mean what it used to. In Canada, the courts use a definition of equality called substantive equality, and this is the result of activist changes to law in the past couple of decades, groups like the Women's Legal Education and Action Fund being the principal architects of these changes. But what's the difference between equality as a normal person understands it and equality as defined now in the courts? Well, substantive equality, as used in the courts, considers not just individual people, but also the relative treatment of those people's ethnic or sexual demographics in history. In other words, people in the same demographic as you were mistreated in the past. Well, under substantive equality, the court will give you a legal advantage over somebody whose demographic was not mistreated the same way in the past. When I phoned the West Coast offices of the Women's Legal Education and Action Fund, and I asked them for an explanation of substantive equality, they told me this. And to make sure that I understood them, I suggested back to them that it was like having a golf handicap built into the law, and they agreed with me. I was essentially correct. And if you think this new and improved version of equality sounds maybe racist or sexist or, psychopathic, well, you're already familiar with the usual array of insults that will be used against you. And while I've spent a lot of time talking about false accusations on this channel, these accusations are, in a sense, a byproduct of something running a lot deeper. Now, if I were to say that we are now seeing the results of decades of activism attempting to overturn the philosophical basis for Western civilization, you might think that sounds crazy, like a conspiracy theory, and I wouldn't blame you. And if I were to suggest that the rule of law, rather than the rule of somebody's opinion or the rule of one social class over another, that the rule of law is being systematically done away with, you might think my tin. The problem is I've yet to hear anyone else offer a better explanation, and I'm not willing to just do nothing while our culture built on prizing the truth and built on the individual is systematically burned to the ground. We are, in my opinion, losing the rule of law. And it's not just a policy that might be replaced after a new political party wins another federal election. It's a bit bigger than that. I think it took, about 1,500 years to develop. So I think we should probably not so easily throw it away. Anyway, thanks for subscribing, thanks for listening, and as always, have a lovely, lovely day.